Coming up next on Arizona Horizon, a midterm U.S. Supreme Court review. We'll look at major decisions this session and a preview of pending cases. Also tonight, a study shows that keeping cool indoors could be making for higher outdoor temperatures at night. Those stories next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. A midterm look at the current U.S. Supreme Court session shows that several big cases have already been decided, with a number of other notable cases still pending. ASU Law Professor Paul Bender is here to talk about what we've seen so far this go-round. Good to see you again.
Nice to see you.
Let's just, in general, thoughts on the term so far?
Yeah, well, you know, it's near the end of the term because the term starts in October and ends at the end of June. But in fact, the term's only about half over because most of the important cases are decided near the end of the term. It looks like they'll decide about 75 cases, which is what they've been doing recently. And they have about 30 more to go. And they tend to be the more important cases. But up until now, they have decided at least 3 cases that are quite important, and there are about 5 cases that are yet to be decided that are potentially very important. So this could end up being a really important term. There's no big blockbuster, you know, like the gay marriage case. But these are, as you'll see in a minute, the cases they've already decided have the potentiality of really changing things.
Well, let's start with affirmative action there. This case, was this a Michigan case?
That's from Michigan, yeah. But it affects Arizona because we have exactly the same constitutional provision that was involved in the Michigan case. Michigan has a constitutional provision, as does Arizona, that prohibits the universities, the state universities, from engaging in race-conscious affirmative action. And the question is whether that was constitutional. The prohibition of affirmative action was constitutional. And the lower court, in an embanked sitting, the Court of Appeals, held narrowly that it violated the Equal Protection Clause because it disadvantaged minorities, because it was minorities who would be wanting to get these affirmative action programs. And anybody else could go to the university and say, hey, start an affirmative action program for athletes, alumni children, flute players, whatever. They can go and the university is free to do that. But if a minority group goes and says we want an affirmative action program for members of our group, the state constitution prohibits the university from doing that. That was the basis of the lower court decision, was that, and there were some previous Supreme Court cases that seemed to support the idea that if you make it harder for minorities to get something done on their behalf than is true for other groups, that's unconstitutional. And the court in this case said, you're overreading those cases. They really don't mean that. That the only time it's bad to stop people from doing something to help minorities if the minorities have been harmed in some way. But here, the court says, the fact that there are very few minorities in the university, that's not legally cognizable harm. The university has a right to have an affirmative action program, but doesn't have to. And therefore, if the voters want to take over and say, well, the university can decide not to have it, so why can't the voters decide not to have it? They ought to be able to decide we don't want any affirmative action program.
That seemed like the bottom line there. It's just the court basically saying, let the voters decide.
Yeah, let the voters decide, right. And so what that means is that any state would now be free to adopt a constitutional amendment prohibiting its universities from having affirmative action. And that could be a disaster for the diversity of American universities because schools continue to generally use admissions formula for the general population, which have a discriminatory effect upon minorities. If you use, like if our law school just used our usual criteria for admission, we'd have very few Hispanics, very few blacks, almost no American Indians. And so if schools can't use affirmative action, that will really change the face of higher education. And this authorizes states to adopt constitutional provisions that would stop that kind of affirmative action.
Was this decision expected?
Yes.
Okay, no surprise there.
No surprise at all. It was 5-4, but it was expected, yeah.
Okay. Another case decided involving starting government meetings with sectarian prayer. What's this all about?
Well, what it's about is a city council in New York started at city council meetings. And a city council meeting is not like a legislature's meeting because the people come there and they make proposals. The city council does all kinds of things. So at the start of the meeting, with the city council people up in the front, but people in the audience who were getting ready to make presentations, they started with a prayer. And for about 10 years, they only had Christian prayers, and some of them were really overtly sectarian. People making the sign of the cross and invoking Jesus Christ. And the Second Circuit said, you can have prayers, but you can't have prayers that are that consistently one religion and that openly sectarian. And the Supreme Court took that case, which really surprised me, because I said, what are they going to do with that? They are in a real fix, the Supreme Court. They can't really say that you can't start an official function with a prayer, because they start their official functions with a prayer, number one. And number two, because Congress has always done that, and because they held that state legislatures could do that some years ago. On the other hand, it does seem to a lot of people, including the dissenters in this case, a little bit unseemly to have a governmental function started with a really strongly sectarian prayer. Let's ask our God, not your God, but our God, for help in doing things. But the only way the court could deal with that would be to say, you can pray, but it has to be a bland prayer, a non-sectarian prayer. And I think Justice Kennedy correctly says that that's not a thing a court ought to be doing, is censoring prayers to make sure they're non-sectarian. But still, you don't want to let them do anything at the beginning of a meeting. So he shifted it from saying what I think what the dissenters wanted him to say was the prayer has to be non-sectarian, to saying, well, you can have a sectarian prayer, but you can't have it be so strong that you seem to be proselytizing or you seem to be expressing a discriminatory attitude. If you do that, then that would be unconstitutional. So the courts still have to draw the line between permissible and non-permissible prayers, but they move the line over toward the sectarian end of the scale.
So okay because it's ceremonial, okay because it's a national tradition, but don't denigrate, don't proselytize.
Yeah, I'm glad you said ceremonial, because Justice Kennedy, in his opinion, invented a new term for me.
Oh, really?
A ceremonial prayer.
Yeah.
That seems to be an oxymoron
All
to
right.
me.
So basically, this is you don't think this is over? We're going to see more cases along these lines?
Well, you may. What you'll see is an outpouring. A lot of city councils were reluctant to start with prayers. Some had done it, they were challenged, and they stopped. But I think this may give rise to a lot of places doing it. And if the prayers get really strong, then there will be litigation about it. But it really does change things in the country from a time when prayers at these kinds of meetings, government meetings where the public participated, I think were going out. And people realize that's really not a good thing to do. It's one thing to have the legislator, it's something where only legislators are there. If the legislators want it and nobody's complaining about it, who cares? But here you have people who come to petition the city council, argue cases before the city council, want a zoning variance,
right.
And so suppose you are a Muslim or an Orthodox Jew, and the prayer is very strongly Catholic or Christian, something like that. What are you supposed to do? They ask you to stand. The person giving the prayer says, everybody stand. If you don't stand, and now you're about to argue to the city council that you want something, and you're showing that you're a dissenter, that's very uncomfortable. So to me, the right answer is there shouldn't be any prayers at all. But if there are going to be prayers, I guess I favored the dissent, saying, okay, if they get to be too sectarian, then the court should strike them down. That's vague, but at least it puts some brake on it.
All right, we also had a case, and we've discussed this on the program before, the McCutcheon case, overall limits on campaign contributions struck down. You still got the caps on the donations to single candidates, but the aggregate is now adios?
The aggregate is now adios, and I think it is another step toward adiosing the individual caps. There are 4 people on the court who clearly don't like any restrictions on campaign financing. But Justice Kennedy, up until now, has been unwilling to go along with it. So they've been eating away at laws. And in this case, what they said was there was a federal law that capped the total amount you could give to all candidates in all federal elections at a particular cycle. It was a lot of money. You know, I think it was about $100,000. But you couldn't give $100 million to all candidates. And the court said, no, that's unconstitutional, because the only thing that justifies limiting campaign contributions is a quid pro quo exchange. That is, I'll give you a contribution if you do something for me. And this was not tailored to that. This just said that people could not give more than a certain amount of money to all the candidates all around the country. And they said, well, that doesn't turn on whether they're getting something back for it. That doesn't have to, and the court says it's got to be direct. I'll give you this, you give me that. Therefore, it wasn't corruption that the states or the federal government was entitled to fight. So that opens up the possibility. It's really interesting, because people can, say in Arizona, if you have a lot of money, you can not only really influence elections in Arizona, you can influence elections in New York, in California, in Maryland. You can give your money anywhere you want. That seems to me to be, people complain about Citizens United, and that's a problem. But this, in some ways, seems to me to be even worse, because it is removed. What you're having is people from one part of the country trying to influence elections in another part of the country. That is, people in New York are going to influence what people in Iowa vote for Congress, for the state legislature. That the use of money to do that kind of thing strikes me as being a little bit against democratic traditions.
Real quickly, was it unusual that Justice Thomas wrote a separate opinion? He basically wants to get rid of all of the limits, and Justice Breyer read his dissenting opinion from the bench. Unusual in any way?
The first is not unusual. Justice Thomas has a lot of positions on constitutional issues that he is the only one who takes that position, and he's staunch about it. He's not going to change. Breyer reading his opinion in that case from the bench is a little bit unusual. He doesn't usually do that. He doesn't usually get that upset. But I think it's because he really thinks that this. I think he sees what's coming. Mm-hmm. What's coming is removing all restrictions on campaign finance laws. So he sees coming that the court's going to just open the floodgates completely to money dominating elections, and he thinks that's a bad idea.
There are a number of pending cases, and we can't get to all of them, or even most of them, or even more than maybe one of them. But the one I think seems to be very interesting to you involves search and seizure and cell phones.
Yeah, that's potentially a very big case. At the end of the term, the court heard two cases that raised the question of whether, when you get arrested for anything, going through a stop sign or murder, doesn't matter, whether if you have a cell phone on your person, the police are entitled to seize it without a warrant and to go through it, look at everything in it without a warrant. And the government is taking the position that they can do that. And I think the court's going. It's really the first time when the court really has to face how the digital revolution affects the Fourth Amendment in a really important way. Because what the government says is, hey, if you had a bunch of papers on you, they could look at those. Well, all a cell phone is a bunch of papers. You know, maybe 1 million papers instead of 5, but what's the difference? So that's going to be very interesting to see what the court does with that.
What do you think the court's going to do with that?
I think they will put some limits on police ability to look at anything on your cell phone. It's hard, because what they should want to say is, you can look for the stuff that's related to the reason you arrested the person, but how do you do that with a cell phone?
Right.
When you're looking for one thing, you're going to find other things.
Right. I mean, anyone on the list all of a sudden becomes part of the. Okay, real quickly, there's one more I want you to get to, and this involves the president's recess appointment power, because to me, this is a quietly very important case.
It's potentially very important, yeah. The recess appointment power is an anomaly, and it really doesn't make sense anymore. The recess appointment power was put in the Constitution at a time when Congress the Senate was in session for maybe 3-4 months of the year, and then they would go away, and for 6 months they wouldn't be there. Well, the Secretary of State leaves office. You don't want to say to the president, you can't have another Secretary of State, so they gave him a recess appointment power. The recess appointments is one where the president can appoint without Senate confirmation, and the appointment lasts till the end of the next legislative session. After the Senate comes back, they can decide what to do. Well, that's not true anymore. There are no real long recesses.
Yeah.
And so what presidents have done is continue to use the recess appointment power, because, as you know, many presidential, say, nominees just they don't vote on them. So the president says, okay, I'll wait for you guys to leave for the weekend and I'll appoint a recess appointment. And that's what's at issue in this case, is whether in those very brief recesses the president can make a recess appointment.
Is there any hint how narrow or how broad they could decide that case?
It could be very, there's a whole spectrum of different decisions that they could make. And I don't think there was, I listened to the argument, I didn't see any indication of whether it's going to be broad or narrow. And I'm not even sure what they're going to do about it. It's a real dilemma for them, because the president has people he needs to appoint. Congress is not doing its job. Should the president have a way to get around that? That's the issue before the court.
And very quickly, the concept of the filibuster, which seems to, the definition seems to have changed here in recent years, how does that factor in
Well,
there?
the fact that they have gotten rid of filibustering of judicial appointments, I think, has some effect upon this decision, because that makes it harder for the Senate to slow up those appointments. So that tends to support the side that would say the president cannot make these appointments. But this case does not involve judicial appointments. This case involves the members of the National Labor Relations Board, and the Senate wouldn't fill them for a long time. And so the board didn't have any members. And you can stop an agency for doing something with that. And so the president said, okay, I can't let that happen, so I'll wait till they leave town for a couple of days and I'll appoint somebody. That doesn't seem right either.
All right. Well, lots of good stuff there, and when the session ends, we'll certainly invite you back, because there's a lot more to talk about. Good to see you again.
Okay.
A new report by ASU researchers shows that nighttime temperatures in the Phoenix area increase 1 to 2 degrees because of excess heat being released by air conditioners. Joining us now to talk about their report, ASU mathematics professor Alex Mihaloff and Francisco Salamanca, postdoctoral research scientist at ASU. The Mathematics and Statistical Sciences, I believe, is where you are. Okay, good to have you both here. Are we talking about air conditioning units contributing to global warming?
Yes. So air conditioning is sort of like refrigerator. So you cool your house, but then you have waste heat, and then it increases urban heat island by 1-2 degrees.
And anyone who stood by the air conditioning unit outside, or if they've been on the roof when it's on or anything like that, they know that warm air does come out, but this influences more at night than the day. Why is that?
Because during the day, the energy coming from the sun dominates. So even if you are ejecting an anthropogenic heat outside, the effect in the temperature is small. However, during the night, this effect is stronger.
How'd you do this research? How was it conducted?
So research was funded by National Science Foundation, and so we run high-resolution model. It's a meteorological model coupled with building energy models. So we take into account everything.
Okay, but again, it was over a certain period of time, were certain areas focused on? What did you get there?
So we used one period in July 2009 just to validate our model. But our research is fundamental research that can be applied to Phoenix and other metropolitan areas.
It sounds like a 10-day period there in 2009. And again, when you went into the research, what were you specifically looking for?
We were looking for the effect of the air conditioning in the air temperature. At the beginning, we were not expecting this magnitude, so it was a surprise, this significant effect. But really, our focus was the effect of the air conditioning on the air temperature.
And it's basically like the urban heat island effect as well. You get more air conditioning units together, more of an effect, I would imagine.
Yes, the air conditioning contributes to increase the urban heat island. So in July, the urban heat island in Phoenix is around 10, 12 degrees. So 2 degrees are responsible from the air conditioning.
And again, as far as just doing the study in the first place, whose idea was this? Who said, hey, let's go find out? Because everyone knows that there is waste heat coming out of their air conditioning units. Whoever thought to say, hey, let's see if this is affecting the atmosphere?
Francisco.
Francisco, all right, Francisco. What made you go out there and look for this?
Some years ago, during my thesis, I was trying to understand this effect. So in the past, I applied in Madrid. So why not in Phoenix?
Yeah, and you said you were surprised by the findings.
Yes, I was waiting a smaller effect. But Phoenix is a big city, and the outdoor temperature is very high in summer, so the effect is stronger.
Yeah, and you also now looked at electricity use as well, and how did that factor in here?
Yes, actually, 1-2 degrees, it's a lot. 1-2 degrees matters. So I brought with me my air conditioning bill,
right, yeah.
and I can compare June and July.
Right.
So in July, average temperature was 1 degree higher, and my bill is $30 more.
Yeah.
So now if we have 1 million households in state of Arizona, multiplied by 30, it's $30 million per month.
But
In waste heat.
in waste heat, but it seems like it's almost a closed loop here in the sense that it's getting warmer, I need to cool down. I'm cooling down, I'm making it warmer. It just goes round. And
Exactly, it's a negative feedback loop. But we can actually turn it around.
how can we turn it
It's
around?
called waste heat. When you have waste, what you do? You recycle. One solution is actually instead capture this heat, right, from air conditioning and run through water heater. So if you do it, so you get hot water, and then you actually reduce your electric bill. So it's a win-win situation. First, you don't contribute to urban heat island, and then you reduce your water heater bill.
Is that the kind of solutions you're looking for when you started looking at this kind of thing?
No, I was not thinking in this solution. Just I was thinking to quantify the effect of the air conditioning, and that's it. No?
Yeah, so nothing more, but seems to make sense, doesn't it? As far as
Yeah,
the water
makes
heat?
sense. Other point, important point that we can do is if our indoor temperature is working at 75, just increase at 80, for example.
Yeah.
And we save energy, we reduce the impact, and our bill will be lower.
Yeah. So are there other things besides perhaps water heaters? Are there other things that this excess waste heat can be used for?
Well, cooking, maybe some other. We
But
can
I mean-
think about.
But you got to find a way to capture that and bring it back into the house.
Right, but it's probably not a very difficult. But if you think about this magnitude of this problem or magnitude of solution, right? As I said, it's like $250 million. In removing this waste heat and using
Right.
it for good purposes, and plus, on top of that, save on your electric bill and water heater, right? So it's a
Right.
very significant.
So if it's that significant, are you working with anyone now to say, hey, I got something significant here. Let's find a way to capture this stuff and use it again.
Well, we are working, but we would like to work more. And hopefully, after after Horizon, we'll have some phone calls, and we will redouble our efforts.
All right, we'll do copyright discussion after the show there. But yeah, I know, I understand. It makes sense. And again, I wonder if that closed loop idea was something that you thought about as well when you started on this research, when you embarked on this research? Or was it just basically a research project saying, if X, then Y?
Generally, the atmospheric models underestimate the nighttime temperatures in the cities. So this study is important for 2 points. One, we can quantify the effect of the air conditioning. Another point is we are improving the weather forecasting models. Because when we compare the temperature taking into account this heat, the results were much better than if you don't consider this heat.
Yeah, okay, last question. What do we take from this study?
Is to find sustainable solutions. So we identify a problem, and then Arizona is growing, right? And so this kind of problems, we need to transform this into some solutions and have positive feedback loop, always positive
Right.
feedback loop. And I think future is very bright because we can use energy for good purposes.
All right. Well, it's an interesting study. I think anyone who stood next to one of those blowers thinks, man, that's warm temperature. And you're saying it does make a difference. Thank you for your research, and thank you for joining us on the show.
Well, thank you.
Tomorrow on Arizona Horizon, hear from the attorney representing a former Tom Horn aide who alleges that Horn broke campaign laws, and find out about a survey on young people's attitudes toward voting. That's Tuesday evening, 5:30 and 10 on Arizona Horizon. A reminder, azpbs.org. That's where you can find us on the web. You can see past shows, and you can see what we have planned in the future. azpbs.org/horizon. That is it for now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.
Arizona Horizon is made possible by contributions from the Friends of 8, members of your Arizona PBS station. Thank you.